Hello, and welcome to the Ministry of Government Relations two-part webinar on servicing agreements and development levies. This is part one of this webinar series, and in this part, we will cover the legislative framework that allows for servicing agreements and development levies, what servicing agreements are, including common content, and eligible items that may be included in a servicing agreement. We'll also go through two servicing agreement exercises. To begin, we'll very briefly go over the legislation that governs land use planning and development in Saskatchewan. The Planning and Development Act 2007 is the legislation that facilitates orderly planning and development in the province. The Act enables municipalities to regulate land use through the adoption of planning bylaws and other tools. A variety of optional tools provided in the Act allows flexibility for municipalities to address complex development challenges. For example, tools for partnering with adjacent municipalities to address areas of common interest are included in the Act. In this webinar series, we will primarily focus on Part 8 of the Act, which outlines the tools for managing the servicing costs associated with growth and development. There are three regulations created under the Act: the Dedicated Lands Regulations, the Statements of Provincial Interest Regulations, and the Subdivision Regulations. The Dedicated Lands Regulations govern how publicly dedicated lands, such as municipal reserves and environmental reserves, may be used, as well as how money from a dedicated lands account may be collected and spent. The Statements of Provincial Interest Regulations contain 16 key policy areas where the province and municipalities have a shared interest and outline associated policy statements. All planning documents and decisions must conform to the statements insofar as it's practical. The Subdivision Regulations contain the technical details for processing and reviewing applications to subdivide land. The legislative framework influences how municipal planning bylaws, such as official community plans and zoning bylaws, work. Let's take a closer look at the tools in Part 8 of the Act. There are two distinct tools in the Act for managing the servicing costs associated with development. Development levies, addressed in sections 169 through 171, are tools that allow municipalities to recover capital costs where there is no subdivision of land. Servicing agreement fees are addressed in section 172 and are a tool that allows municipalities to recover capital costs where there is a subdivision of land. The Act also defines capital costs to outline the scope of costs that can be included in these charges. Capital costs are the municipality's estimated cost of providing construction, planning, engineering, and legal services that are directly related to the matters for which development levies and servicing agreement fees are established, but do not include any cost of maintaining roadways, other related infrastructure, and public facilities. It's important to remember that not all capital costs are eligible to be charged using these tools. A development levy or servicing agreement fee can only be charged once to the same development for the same capital costs. However, if a development intensifies or expands, a levy or fee specific to the new portion can be charged. We'll talk about eligible costs later. So why does the Act include tools for managing the costs of growth? While new development brings a series of benefits to a community, it also has an impact on services. Often, new development brings an influx of new people, jobs, or activities to a community that increases the demand for infrastructure. For example, increased water use or sewage disposal. In some cases, the development being proposed may trigger the need to immediately upgrade a municipal service, such as upgrading sewage lagoon capacity to accommodate a new residential area. Part 8 of the Act recognizes that municipalities incur capital costs from new development. An increased use of services leads to increased costs for the community. The framework is set up to ensure that new development is paying for itself and not imposing too much of a burden on the existing tax base. Affordability is at the top of mind, and using cost recovery tools properly can help make sure that new development doesn't cause a steep increase in taxes to meet service requirements. It's valuable for a municipality to retain professionals to help assess development costs. For example, if you retain an engineer to assess the capacity of your sewage lagoon, the cost for the assessment could be incorporated into the fees charged under the servicing agreement. Let's start with servicing agreements. As we go through this information, keep in mind that this is a tool used when there is a subdivision of land involved. Servicing agreements are used to achieve two main objectives. 1. Outline the standards for the installation of new municipal infrastructure by the proponent. And 2. Facilitate the collection of servicing agreement fees, which are for recovering the capital cost of infrastructure and services not being installed by the proponent. For the next few slides, we will look at some of the common content of servicing agreements. All the content we go over in this webinar is taken from the servicing agreement template available on saskatchewan.ca. The agreements themselves have a few common components that allow for an easier completion process. Interpretation. This includes the definitions and any other clauses for how to interpret the agreement. Plans and design drawings. It's a good practice to have all relevant plans and drawings attached as appendices to the agreement. These can include the plan of proposed subdivision, engineering drawings for elements being installed, or municipal design standards. This ensures all parties are aware of the quality expectations for new municipal infrastructure. Installation and municipal completion process. This includes the proponent's responsibilities while constructing the new infrastructure, such as safety during construction or the management of debris. This section also outlines at what point the newly installed infrastructure will become the responsibility of the municipality. Most municipalities include provisions for a warranty period, during which time the proponent is responsible for repairing any deficiencies. For example, there may be a 2-year warranty period for a new roadway to make sure the work was done adequately. Usually, there are a series of inspections by the municipality's engineer before a new service is taken over by the municipality to ensure it was constructed properly and to municipal standards. Servicing agreement fees. There is usually a section on the amount of fees the proponent needs to pay for municipal capital costs and the timeline for when those fees need to be paid. Indemnity and security. This outlines how a municipality will protect itself from a proponent walking away from the project or not completing the agreed upon work to the necessary standards. Typically, this is in the form of a performance bond or revolving irrevocable letter of credit. The proponent's financial institution issues these and allows the municipality to draw upon funds if the proponent defaults on the agreement. It's important for the amount collected to be comparable to the value of work being undertaken. For example, if the developer is doing $1 million in roadway improvements, it would be reasonable to collect a bond worth $1 million. Each municipality may have a different approach to this, and some may reduce the bond as certain construction milestones are met. In some instances, once half of the overall work is completed to the municipality's satisfaction, half of the bond may be released. This is an important section since this is how the municipality protects the public from having to bear the costs of negligent proponents. Dispute resolution. This outlines the process that will be undertaken to resolve any disputes related to the agreement or standard of work completed. A developer may be required to install several different pieces of municipal infrastructure as a part of a subdivision. Typical items are sanitary sewers and water mains, and associated connections servicing each lot, and may also include the landscaping of parks and the installation of playground equipment. While this section is broad, allowing council to require other items outside of those specifically listed, these items must relate to the proposed subdivision. The Act is specific in the types of services and infrastructure that may be included in a servicing agreement fee. Eligible items include the capital cost of providing, altering, expanding, or upgrading sewage, water, or drainage works, roadways and related infrastructure, parks, and recreation. Maintenance and operating costs are not eligible under the definition of capital costs in the Act. Eligible costs incurred in neighboring municipalities can also be charged back to the applicant. The reason this is allowed is to recognize that growth in one community can affect the services of neighboring communities as well. It's important for the municipality to reasonably demonstrate the link between the development and an eligible capital cost under the Act. Any costs need to directly or indirectly service the development. Ask this question: how does this development contribute to the municipality's capital costs? If the costs do not directly or indirectly service the development, the applicant could appeal the fee to the Saskatchewan Municipal Board. Now we'll go through 2 servicing agreement exercises to put into practice the information we've gone over in this webinar. We encourage you to pause the video and think about the applicable on-site infrastructure that the developer may be required to install, as well as applicable off-site costs related to the subdivision shown on screen. On-site services the developer may be responsible for include constructing a water line throughout the subdivision to service each lot, the development of roads throughout the subdivision, the development of the land to be dedicated as environmental reserve, which could include grading, and the installation of culverts to drain water through the subdivision. Off-site costs that may be charged to the developer include the installation of culverts to drain water away from the subdivision, the upgrading of Range Road 7 from a summer road to an all-weather road, as it will now be used throughout the year, the extension of the rural water pipeline to service the subdivision, costs to cover the expansion of the municipality's sewage lagoon to accommodate the waste generated by the subdivision if holding tanks are to be used. If the waste will be disposed of in another municipality, this cost may be paid to that municipality. The potential upgrading of any roads servicing the subdivision, and a portion of the cost to develop municipal-level parks and recreation facilities. Similar to the previous exercise, we encourage you to pause the video and consider the applicable on-site infrastructure that the developer may be required to install, as well as applicable off-site costs related to the subdivision shown on screen. On-site services the developer may be responsible for include constructing water and sewer mains throughout the subdivision, water and sewer connections to each individual lot, developing drainage systems throughout the subdivision, the development of roadways throughout the subdivision, including curbs, gutters, and boulevards, developing the land to be dedicated as municipal reserve and as a buffer strip, including pathways, park equipment, and lighting, hydrants throughout the subdivision, streetlights and nameplates, and connections to existing roadways. Off-site costs may include the development of the undeveloped portions of road, the extension of water and sewer mains to service the subdivision, drainage required to accommodate stormwater generated by the subdivision, such as drainage ditches, swales, or stormwater mains, and a portion of the cost to develop municipal-level parks and recreation facilities. This concludes the first webinar in this series. Part 2 will cover development levies, opportunities for appeal related to development levies and servicing agreements, and best practices when employing either of these tools. Thanks for watching.